Hello guys, my name is Tejas Sudhakar K and we are back with another video. So in today's video, we are going to do a small yet an important topic for your company law examination. That is your section 184. That is disclosure of interest by directors. Okay. First, let's understand what does this section deal with. Why do we have this section before we actually start interpreting the provisions? And as always, this is one of the most important video for your examination, and with just this short video you will be able to cover everything about section 184. So without any further delay, let's just get started. Okay, now section 184, what does it say? Disclosure by a director of his interest. Disclosure of his interest. Now let's say there is a company called as ABC. There's a company called as ABC Limited. In ABC Limited, who is the director? Mr. A is the director. Who is the director? Mr. A is the director. Okay. Now, there is another company called PQR Limited where Mr. A is a shareholder and he is also a director and he has a substantial stake in PQR Limited. Now, don't you think A would always prefer that ABC Limited enters into contract with PQR? Arey, why? Because Mr. A has a share in PQR Limited. He has a stake in PQR Limited. Okay? Because he is so invested in that company, he would want that company to do well. So he would make sure that the contract from ABC would go to PQR Limited. Now tell me one thing, isn't this a conflict of interest? This is of course a conflict of interest. See, go back to your basics. Go back to your basics. Who are directors? Directors are agents of the company. Who are they? They are the agents of the company. So whenever you are an agent of the company, when you are a director of the company, you should act for the benefit of the company, for the benefit of the company. You should act for the benefit of the company. You cannot act for the personal intent, for your personal gain. Now, what is Mr. A doing? Now, let's say Mr. A has an arrangement with PQR saying that if at all you get us a contract with ABC, we will give you this much commission. Now, don't you think even if the contract is not so good, let's say contract is not beneficial for ABC Limited, but this person would always push to enter into contract with PQR. It is not beneficial to ABC Limited, but he would still want ABC to enter into contract with PQR. Is this for the benefit of shareholders? Is this for the benefit of the company? Absolutely not. Okay. So what should you do? You should act for the benefit of the company and the shareholders of the company And to avoid this from happening, that is the reason you have section 184. So section 184 mainly deals with interest of a director in other companies. Now, what is the benefit of knowing that this director is interested in another company? This is to ensure one is transparency. One is to ensure transparency. Second, and that ensure that there is no conflict of there is no conflict of interest. There is no conflict of interest. Okay, there's no conflict of interest. Okay, to ensure these two things. Okay, so this is the main purpose of why we have section 184. Is it clear? Broadly and in the most simplest form, there are only two purposes. One is to ensure transparency. Shareholders should know, okay, if he is a director in my company, I should also know in which other company he is interested in, which other entity he is interested in, Which other entity is he a director? In which other entity is he a shareholder? How much shareholding is he having? Because tomorrow, if at all the company enters into contract with the other company in which he is a shareholder or a director, shareholders are aware about it and can take appropriate decisions. Okay, so this is the purpose of section 184. Okay, now your coming to your Bear Act, the provisions. Section 184 states that every director, okay, every director, does not matter he is an independent director, does not matter he is a small shareholder director, does not matter he is an alternate director, does not matter if it is a woman director, does not matter he is an additional director, does not matter. Every single director has to disclose what? Okay, what are they telling? Has to disclose his concern or interest in any company or companies or body corporates or firms or other association of individuals. Okay, so first thing, what is section 184 imposing? It is imposing an obligation. On whom is the obligation being imposed? On every director of every company. Okay, so section 184. What does it say? Every director shall disclose what? Every director shall disclose his concern or interest where a company or companies or firms firms, then other and other body corporates, other body corporates, then any association of individuals. This has to be disclosed. Every director shall disclose his concern or interest in companies, firms, body corporates, and association of individuals. I hope this is clear. Okay. So first thing, let's quickly revise. Section 184 talks about an obligation to disclose concern or interest. Who has this obligation? On whom is this obligation imposed? On every director of every company. Okay. What should he disclose? His concern or interest in companies, firms, body corporates, and association of individuals. Simple. Okay. Then let's move forward. Okay. Now the question is, who should disclose and what should be disclosed? They have answered. Till now, what have we seen? Who should disclose? Every director. What should they disclose? Concern or interest. Now, when should you disclose? Okay, at the first board meeting of the board. So basically, your first board meeting in which he participates as a director. Let's say he was appointed as a director on 1st August 2025. He was appointed on 1st August 2025. The immediately next board meeting was 10th August 2025. Now on 10th, the board meeting which was held on 10th August 2025, he should disclose his interest because for him that is the first board meeting in that company. For example, Mr. A is appointed as a director where? At in ABC Limited. Okay, he was appointed in ABC Limited. Okay, let's say on 1st August 2025.
And the next board meeting, the immediately next board meeting next board meeting was held on, let's say, 7th August 2025. Can I say it was held on 7th August 2025? Now, on this board meeting, that is 7th August 2025, on 7th August 2025, he should disclose his concern or interest in the five places: company, companies, firms, body corporates, and association of individuals. Okay, if you look at it, this is the first board meeting for Mr. A in ABC Limited, which is it? The board meeting held on 7th August 2025. Now let's read the provision once again. Section 184 states that every director shall at the first board meeting, okay, in which he participates as a director, in which he is participating as a director, and thereafter, okay, this is first board meeting in which he is participating as a director. So when should it be disclosed? When should it be disclosed? It should be disclosed at the first board meeting, at the first board meeting after his appointment as director. Okay, this is your first scenario. Then and and at the first board meeting after at the first board meeting of every every financial year. Every financial year, whichever is your first board meeting, you should disclose your concern or interest. For example, when will your financial year generally commence? On 1st April. Let's say we are talking about 2025-26. When did your financial year commence? 1st April 2025. And the first board meeting for that particular financial year, which year? 2025-26. Let's assume that it was held on 5th April 2025. So again on 5th April 2025, again he should disclose his concern or interest in the company, companies, entities, so body corporates, firms, and association of individuals. And the another scenario where another timeline for disclosure of interest is, and okay, and at the first board meeting at the first board meeting after the change has occurred, after the change in his concern or interest. Okay, now let's say you are a director in one company. You were appointed when, let's say, on 10th 10th September 2024. On 10th September 2024. Okay, your immediate next board meeting, I will assume it to be on 15th September 2024. Should you disclose on 10th September 2024? Yes. Then your financial year commenced, the next subsequent financial year commenced on 1st April 2025. Okay, but the next board meeting after the first board meeting of that particular financial year. So what would be the next financial year? 2026, 27. So let's assume that on 5th April was the first board meeting of 2025. So for 2025-26, what is the first financial year? 5th April. It is 5th April. So on 5th April, again you should disclose your concern or interest. Then let's say on 1st August 1st August 2025, 1st August 2025, what has happened? There is a change in your concern or interest. Basically, you have stopped being a shareholder in one company, or you have become a director in another company in which you were only a shareholder, Now, in those companies, okay, now in those circumstances, let's say the change occurred on 1st August 2025 and the immediate next board meeting was on 5th August 2025. Again you should disclose on 5th August 2025. Again you should disclose that there is a change in my concern or interest. These are the three scenarios where you will be disclosing your concern or interest in other companies, body corporates, firms, and association of individuals. Okay, I hope the timeline is clear. Pretty much simple. First board meeting after you were appointed as a director, then first board meeting of every financial year, then first board meeting after the change has occurred in your concern or interest. Okay, then coming to 184.2 states that every director, again the obligation is on every director, okay, of a company who is in any way, whether directly or indirectly concerned or interested in a contract or arrangement or proposed contract or arrangement to be entered into or to be entered into. Now, what are they telling? If at all there is a director, now we are specifically talking about interest not in companies, firms and all. We are talking about concern or interest where? Concern or interest in contract or arrangement. Where are we talking? Concern in contract or arrangement. Now if at all the company wants to enter into a contract, okay, now let's change the example. Instead of PQR Limited, now, what was the example I gave? Instead of PQR Limited, let's say Mr. B. Mr. B. Mr. B is the brother of Mr. A. Now, Mr. A would, of course, would want the contract or arrangement to go to his brother, right? Now, is this inherently bad? Is this by default bad thing? No, it is by default not a negative thing. It is by default not a negative thing. Okay? It is by default not a negative thing. It's just that we should be careful about it. And if at all, even in jurisprudence, you would have studied one legal maxim which says that you cannot be judge in your own case. Similarly, if at all ABC Limited now is considering to enter into contract with Mr. B, where will it consider that I have to enter into contract with Mr. B? In a board meeting. Now, do you think it makes sense to allow Mr. A to go and vote in that board meeting? Of course not, because we know that he would vote for the resolution. He would want ABC to enter into contract with Mr. B, of course. So that's the reason 184.2 states that 184.2 states that now, if at all there is a contract or arrangement or proposed contract or arrangement entered into or to be entered with a body corporate in which such director or such director in association with any other director holds more than 2% shareholding, okay, more than 2% shareholding of that body corporate, or is a promoter, manager, chief executive officer of that body corporate. One is you are holding more than 2% of the shareholding, or you are a promoter, or you are a manager, or you are a CEO. Okay, then or the other scenario, or with a firm or other entity. Okay, remember, body, corporate, firm and other entity in which such director is a partner, owner, member. Here only three things: partner, partner. What do you mean by firm? Generally whenever I say firm, I mean partnership firms, your LLPs. Okay, partner, owner, or member, okay, as the case may be, shall disclose the nature of his interest. Now you should disclose the nature of his interest. Whose interest? Mr. A's interest. Okay, at the meeting of the board in which the contract or arrangement is discussed, and this is important, shall not participate in such meeting. Okay, now 184.2 has two parts. Section 184.2 has two parts. Section 184. Section 184 has two parts. One is body, corporate, and the other one is body, corporate, and the second one is firms, entities, firms, entities, okay, firms or other entities. Now, when you are a body corporate, what are the four requirements? Either you are holding more than 2%, 2% shareholding, 2% shareholding, or you are a promoter, or you are a promoter, or you are a manager, or a CEO. Okay, and when it comes to firm or entities, you are a partner, or you are a owner, or you are a member of that firm or entity. Then if this is the case, if this is the case, if this is the case, disclose the concern or interest. Disclose the concern or interest at the board meeting. Which board meeting? In the board meeting where this contract or arrangement is being carried out, and shall not, shall not, shall not participate in such board meeting. In such board meeting. That's it. This is your section 184.2. Okay, let's, before looking at the provisos, just pause the video right now. Just pause the video right now and go through the provision 184 and 184.2, and I believe you should be able to understand it. Okay, then provided that where any director who is not so concerned or interested at the time of entering into such contract, now they are talking about a scenario, you were not interested in this contract or arrangement at the time when you were entering into a contract, but after the ABC Limited entered into this contract later on, see, till now, what was the requirement? Mr. A should have been interested in the contract or arrangement before it was approved. Now ABC Limited is entering into contract, let's say, with PQR Limited. Now this 184.2 will come only when he is already interested in contract or arrangement before it is approved by ABC Limited. Now this proviso is talking about a scenario or a possibility where the contract or arrangement is yet to be entered into. Okay, sorry. In this proviso, the contract or arrangement is already approved, but when it was being approved, Mr. A was not interested, but he became interested after the contract was approved by ABC Limited. Now what should be done? Then simple thing, disclose his concern or interest when he becomes concerned or interested at the first board meeting. Let's say let's say the contract was approved on 1st April 2024. Okay, it was approved on 1st April 2024, and at this point of time Mr. A was not interested. He was not interested at this point of time. He was not interested at this point of time. But later on 5th April, on 5th April, Mr. A became interested. Now he became interested. Became interested. Okay, see, no one would have predicted this. Now what should Mr. A do? Let's say the next board meeting was on 30th April. Next board meeting was on 30th April 2024. Okay, that is your next, in fact, immediately next board meeting. Next board meeting was on 30th April 2024. Then again, Mr. A shall shall disclose what? His concern or interest. That's it. Okay, this is your section 184.1 and section 184.2. Okay, now coming to 184.3, a contract or arrangement entered into by the company without disclosure under subsection 2 or without participation by director who is concerned or interested in any way, directly or indirectly, in the contract or arrangement, it shall be voidable at the option of the company. Let's say Mr. A was supposed to disclose the interest, but he does not disclose the interest, and ABC Limited enters into contract. Now this contract becomes voidable. At whose option? Voidable at the option of the company. Going back to your basics of contract act, what do you mean? I hope you guys know the difference between void and voidable. If at all the company is fine, okay, he did not disclose his concern or interest, and even though he did not disclose it, we are still fine with the contract or arrangement, we will go ahead. Even that option is there. But if at all they feel that, oh, he should have disclosed it, and because he has disclosed it right now, we do not want to enter into contract, or we do not want to continue this contract or arrangement, then such contract or arrangement becomes voidable. So this becomes a voidable contract. You have to understand the difference between a void contract and a voidable contract. Okay, I hope this is clear. It is also stated that nothing in this section shall be taken to prejudice the operation of any rule of law restricting a director of the company from having any concern or interest. So a law, let's say SEBI regulations, okay, is telling you that you should not enter into any securities contract. It does happen whenever you are being investigated or you are convicted of committing fraud. SEBI can come up with these regulations. Isn't this operation of law? Because of this law, you are not allowed to enter into contract. Section 184 will not affect those laws which are restricting you to have any concern or interest. Okay, so what will prevail? So any operation of any rule of law restricting a director of a company from having any concern or interest. So nothing can stop you from having concern or interest, and it shall apply to contract or arrangement entered into or to be entered into between two companies or between one or more companies and one or more body corporates, where any of the directors of one company or body corporate or two or more of them together hold not more than 2% of the paid up share capital in other company or body corporate. Okay, I hope this is clear. Now here they are talking about if at all you are having up to 2%, then it shall not apply. What are they telling? Okay, that's it. If you remember this much, this is more than enough for section 184. Okay, so what is the first one? Section 184 shall not apply or shall not restrict any operation of rule of law. That is your first exception. Second, where you are holding less than or equal to 2%, then we have no issues. We only have an issue when you are holding more than 2% of your paid up share capital. Here we do not have an issue. Here we have an issue, that is when you are having more than 2%. Now what is the penalty? Penalty of 1 lakh rupees. I think you guys can go through the penalties. Now which form are you filing? MBP 1. Every director shall disclose his concern or interest in any company or company's body corporate. Is the same thing by giving a notice in MBP 1. Whom is he giving this notice? Notice to the company. Notice to the company. It shall be the duty of director giving notice of interest to cause it to be disclosed, and now he has to make sure that this is disclosed in the upcoming board meeting, that is immediately next board meeting. He has to make sure that this notice is disclosed. All notices shall be kept at the registered office and shall be preserved for a period of 8 years. Now this third point is an obligation on the company. It is an obligation on the company. That is it. This is your section 184. Okay, even though I have taken quite a lot of time for section 184, but I don't think beyond this there would be any question that will be coming. If you have understood this, I don't think you will have any difficulty in understanding this topic and going and answering your questions. The only doubt that I always get from students and where students gets confused is, let's say Mr. A is director in ABC Limited, PQR Limited, XYZ, DEF, okay, XYZ, PQR, DEF, in all these four companies he's a director. He's a director. Now, now, should he disclose his interest in each and every company? Should he disclose it in each and every company? Answer is yes. He should disclose in MBP 1 in each and every company. If he is disclosing it in ABC Limited, he has to disclose that he is a director in PQR, he is a director in XYZ, and he is a director in DF. If at all he is disclosing for DEF, then he has to disclose that he is a director in ABC, PQR, and XYZ. So in all the four companies, you will be giving notice to all these four companies individually in MVP 1, and you have to make sure that it is disclosed in the upcoming or the immediately next board meeting. And the third point, whatever notice that you are giving to the company, now these companies have to preserve it for a period of 8 years. They have to maintain a register of all the disclosures that is made by the director. Okay, that is it. Okay, let me know if you have any doubts in the comment section. I would be happy to take them. Okay, and the next video, let me know if you have any other particular topic in mind which you would want me to cover. Would be happy to cover that for your examinations and for your better understanding. Okay, so until next time, bye guys, see you.